We have 37 questions, and I'm just going to start right with the questions. Question number 1, if the board deems email to be a reasonable method of providing notice for a board meeting, then can notices just be emailed to the owners? So yes, if you have everybody's email, that's fine. If you don't have everybody's email, then you may want to put it on your website too, just to make sure you get, everybody has notice. Question 2, our HOA board meets an executive session both before and after the open meeting. The meeting notice always lists all 5 statutory reasons, regardless of topic, and the open meeting minutes do not note that an executive session occurred or cite the statutory reason. The management company says this is not required. Is this correct? Also, the board does not include an open forum for homeowner comments. Attendance is low, 3 to 5 owners come, but is the board still required to provide an open forum? Okay, this is a lot of questions, but I'll condense them quickly. Okay, so when you go into executive session, you just have to list either in the notice or the agenda or before the executive session starts, the topics that you're going to be discussing that are executive session topics. So it sounds to me like your association, the meeting notice lists all 5. They probably do that just as a box checker to make sure that they cover everything in case something comes up at the last minute. So your board's doing that correctly. The board does not have a homeowner forum in the open meeting. Well, you're not really required to under the law. So homeowner forum is typically done at the beginning of an open board meeting and allows owners to say, whatever they want to say for a minute or two about things that are going on in your association. You're not required to do that. I think best practices are that you do it, but you're not required to do that. But the board is required, before the board takes formal action on anything, to open up to anybody that wants to talk, that's not a board member, just a homeowner. And they are required to give them a minute or two to comment on anything before the board takes formal action on anything. Like anytime the board's taking a vote is going to be a really good example of that. Okay, question number 3. The recent storm damage is causing our HOA to need to assess our residents $500 each, but our CC&Rs require a ballot to approve it first. Is there anything in Arizona law prohibiting the HOA from collecting the $500 ahead of time from residents who wish to pay now instead of waiting so that we can get this damage cleaned up right away? So I don't have an issue with that. If owners are gratuitously just going to make the payment to help us get this moving, I'm fine with that. Okay, question number 4. We have some members who want to go to a desert landscaping to get rid of their grass. They want to hire unlicensed, uninsured, cheap contractors. Our CC&Rs require them to submit an architectural change request before any work can commence. In evaluating their plan for the ambiance of the HOA and approving it, are we accepting any liability? So this is kind of a loaded question. You have to look at what your documents say about architectural approvals, and you have to evaluate the application based upon that. What you might want to do is you might want to put as part of the approval that, licensed, bonded, and insured contractors must be used. And, prior to beginning the work on this project, you need to provide us with your, contractor's name, license number, and that information so that we're ensured that this is being done. I think best practices always is going to be use licensed and bonded and insured contractors, especially if they're doing irrigation, and they are required to be licensed, bonded, and insured with the Arizona Register of Contractors. So you may want to contact the Register of Contractors if they're not doing that. Make a complaint against whoever they have out there working. Okay, question number 5. As an HOA board member, I submitted a records request for copies of CC&R violation letters sent to homeowners this year. Property manager refused, stating a board vote is needed and offered only a summary report. Am I legally entitled to receive copies of these violation letters as an individual board member without needing the rest of the board to vote or request them? So my feeling is you are entitled to receive that information and your manager should give it to you. It kind of raises a red flag to me, like you're a board member. You have access to everything. And so to require a vote of the board to give that to you seems like they are trying to prohibit you from getting it, making it difficult for you to get it, which I don't think is a good trend. Now, if it has to do with you or something, and this is your personal issue, then, maybe we need to look at this a little differently, because if you're thinking about, like suing the association because of a violation letter you got, you want to like use the information that you have as a board member for your personal use, that could be a little bit problematic. So I want to just throw that out there and say that if that's the case, then maybe the manager and you need to have a discussion with me and can talk that through. Okay, question number 6 from an owner. A homeowner, investment property owner, or realtor in a planned community did not follow the governing documents, rules, and regulations and has outstanding fines and violations on the property's account, and the home is now listed for sale. With respect to violations, the homeowner had the opportunity to be heard and afford themselves that opportunity and have received response to the appeal. Are they obligated as a realtor owner to tell all prospective buyers that the property has fines levied against it and modifications to the home that were not approved by the association? I mean, this is kind of a question that probably needs to go to the Department of Real Estate, but I mean, my feeling is if the realtor has knowledge, they should be notifying the other realtor that's on the other side of the deal, or anybody that they're bringing in to look at the property, that, there's an issue with the violations on this property that need to be addressed before the close of escrow. Okay, question number 7. Our HOA used possible fee increases that were not used in previous years to calculate an increase larger than the CPI. Is this legal? Well, I'm never in favor of doing that. I know that there are some law firms in Arizona that will say that if your documents allow the board to raise the assessment 10% every year, they exercise that right in the minutes, but then they don't collect it. And then at the end of 3 years, after doing that for 2 years, they try to raise it 20% based upon the prior years without a birth of membership. It hasn't been tested under the law yet in a court, but I feel that if it was tested, the association would not prevail on that. I don't think it's a good idea. I think the documents are in place for a reason. You increase it in that year, or you don't increase it, and I don't think you can like reserve it or take advantage of it and not collect it. I think it's going to not go over well with the judge, and I don't think an association will win if you're challenged on that. Okay, question number 8. If homeowners have recently took over control from the developer and builder, should the new HOA board conduct any due diligence with the management company, association records, bank accounts, negotiate and sign new contracts? What would you recommend they do? Okay, number 1, you need to look at our cheat sheet on transition from developer to homeowner control, because in that cheat sheet, we list the most common issues that come up in a transition. And I can tell you with absolute certainty, I don't think I've ever seen a transition from developer to homeowner control where there weren't some issues, minor, major, right in between. The second tip I'm going to give you is you really need to reach out to our firm and have just a short meeting, like 30 minutes to an hour, and talk through the issues. Remember that the management company is often aligned with the former developer. So you want to be mindful of what you're saying to them, and you want to be mindful of any advice they may be giving you, because they're going to get other properties from the developer, and they probably are trying to keep the peace and don't want the developer to get sued or have conflicts. And so you have to recognize they may have a competing interest and may not be giving you, impartial advice or comments on things. So really recommend that you reach out to our firm. We can have a short meeting with you and talk it through, and we'll see if you need to investigate anything further, and check out our cheat sheet too. Question number 9. Is there a difference between a board director and an officer? Can a board appoint an officer to assist but not to vote? What's the title, and is there a resource to define this? We have a great cheat sheet called What is an Association? It's on our website at mulcahylawfirm.com that talks a little bit about the different roles of board members and the difference between a board member at large and an officer, that I would really encourage you to take a look at. Whether or not a board can appoint somebody, like typically an officer, saying but they don't vote, that's pretty unusual, and it would have to be in your bylaws to allow you to do that. Okay, question 10. Is there a standard percentage to pay a property management company, especially based on owner fees and amount in a reserve? No, there really is not a standard percentage. I mean, way back in the day, like 25 years ago, they used to say like dollars per door thing, but that's that whole financial side of how much a management company charges an association has really changed over the years. And what we've seen now more likely is that the monthly fee is lower, but then the add-ons on the exhibits to the contract are what generate a lot of income for the management companies. So short answer is there's no standard percentage. But if you are interested in having us look at whatever your contract is with the management company, we can tell you, like, this is market rate, etc. Okay, question 11. What if board members are related? How do you keep that without suspicion? I don't know what you mean by related. Like, are they brother, sister, or aunt, a niece, or are they husband and wife? I think the best thing to do is to disclose it, be upfront at a meeting, and that can help with the suspicion. I really never like it when a husband and wife are serving on the board at the same time, because I think you should try to find independent people. I think it's too much power rested in one household. And so those are some tips on this. Okay, question number 13. When issues arise that require immediate attention, the board communicates by text or email to resolve them. Are there limitations to this form of communication and decision-making? Well, we talked a little bit about, under number 1 in this presentation, about emergency meetings. It sounds like you're doing an emergency meeting by text or email. Just at the next regularly scheduled board meeting, print out those emails or texts and attach them to the minutes and explain what the emergency was and what the decision was, and that, these are going to be attached to the minutes for this meeting. Okay, next question, number 14. We do work sessions to talk about specific contracts, etc., with all board members. Is that subject to the open meeting law? So yes, anytime a quorum of the board is meeting to discuss association business, even if it's a work session, even if you're not voting on anything, it is still an open board meeting and needs to be noticed as such. Okay, question number 15. We have 5 board members. Can 3 of us play golf together or get together for dinner? The concern is invariably HOA business will come up. What can or can't we discuss? So 3 is a quorum. You shouldn't be discussing anything pertaining to the association. If you're playing golf or out for dinner, it's just not proper. Okay, and against the law. Okay, question number 16. Do the same open meeting laws pertain to working sessions by the sub or master committee? So yes, if they're set up as an association, typically that's going to be like a planned community or a condominium. Yes, it is the same, is going to apply. Question number 17, do the same open meeting laws? Let's see. Yeah. I think, is this the same question? Okay, no. Do the same open meeting laws pertain to committee meetings of committees sanctioned by the board that pertain to board meetings? Oh, this is a good question. I didn't address this in my presentation, so I'm glad you brought this up. So the open meeting law applies to committees and an association that meet regularly. So if you have a committee that is a regularly scheduled committee that meets regularly, they are required to comply with the open meeting law. So if your architectural committee reviews applications the first Friday of every month, that is a regularly scheduled committee meeting. It would need to be an open meeting. If you meet sporadically without any regular schedule, then you're not required to be subject to the open meeting law as a committee. Question 18, are HOA management staff allowed to run the board meeting? Our board rules is that owners can ask questions about an agenda item, but that is not done in practice. I mean, it's kind of unusual that a management staff would run the meeting. Typically, the president is running the meeting, but sometimes if you have a board that maybe is inexperienced or you have a difficult owner that's causing a lot of problems, sometimes the management company will step in to help out. So, are they allowed to run it? I suppose yes, but it's unusual. Next question, number 19. Our board will be making a committee appointment. Can I share my appointment choice with another board member? As long as it's less than a quorum, yes. Number 20. If a regularly scheduled meeting has to be canceled due to unforeseen circumstances, and this happens 3 hours before it starts, how should this be handled? Well, a couple ways. You can, blast out notice to your community. and on email or post it on your website. You can have one person on Zoom. So if anybody shows up on Zoom, you can say, sorry, the meeting was canceled. I mean, that's probably more than what most associations would do, but those are some suggestions. Question number 21, do the regularly scheduled every 2 weeks on Google meetings of the architectural committee need to be noticed and open for homeowners attendance? Yes, because they're regularly scheduled. Question number 22, what is the difference between executive session and a special meeting? Good question. So we've got 3 different meetings here. So we've got like an open board meeting, right? That's where we do our normal association business. An executive session is where we only talk about the 5 executive session topics that we talked about earlier in this presentation. And then a special meeting of the board could be an open meeting or it could be an executive session. It just depends on how it's noticed. Maybe the special meeting is in between the monthly meeting to address a special topic. Okay, question number 23. If the meetings are audio and video recorded by the association, is it required to make both audio and video recording available to the community as opposed to just the audio? I guess short answer would be to be safe, yes. If they want it, if you have both of those recordings, short answer would be to be safe, yes. If they want it, let them make a request. If you are posting it somewhere, you could probably just post the video because it's also the video and the audio at the same time. Okay, next question, 24. If a condo building in an older condo complex had and possibly still has a rat infestation that left a very large amount of rat feces and urine inside the walls, ceilings, and areas in direct contact where the airflow going into the unit's air intake system before being recirculated back into living spaces, what should the association be expected to do to handle it, since it is a building-wide issue and not just a per-unit issue? Ooh, that's gross and scary. Well, I think that there needs to be, first I would get advice from, whoever came in and did the infestation, got that under control, and see what they suggest. You may want to bring in like a special company that deals with, I don't know how serious the infestation was, but you may want to bring in a company to give you some advice about like a hazmat company to see if maybe do some testing in certain areas to see if this is something that does need to be looked into further by your association. I mean, if I were you as a homeowner, I would get an air purifier. I would be, if there's a smell, I think you need to document. Maybe you need to bring in your own expert to, talk about this with your board, because it probably does need to be treated by the association. Maybe covered by the insurance too, don't know. And so if your association board is, ignoring it because they're worried about the cost, this could be something that could be covered by the association's insurance carrier. Question number 25. We often have a quorum of board conspiring to discuss topics via phone, emails outside of the open meeting. Specifically, not meeting in person to circumvent the open meeting law, but coordinating and communicating and making collective agreed upon decisions. This group includes the president and vice president of the board. They consistently exclude other board members. Then they vote together as agreed upon at the next open meeting. Are the prior discussions and decision to coordinate a collective vote in violation of the open meeting law? So I don't know what your quorum is, but I'm assuming that 2 is less than a quorum, and this is okay under the statute. So if 2 board members is less than a quorum, they can talk about issues, they can decide how they want to vote on issues, but it's not a violation of the open meeting law. I'm not saying it's a good thing. I'm just saying it's not a violation of the open meeting law. I mean, obviously, as a board, we talked about secrets of successful associations, right? One of the secrets is your team. And, intentionally excluding other board members or trying to get, doing things like this could undermine the teamwork aspect of being on your board. Okay, question number 26. We are looking at having a special assessment. How would we handle any homeowners that may refuse to pay the special assessment? This is a really good question. So we have a special blog on special assessments, which we're going to be sharing with you. A couple thoughts. Number one, when you're preparing the budget for the special assessment, whatever you need it for, you may want to factor in a delinquency percentage that is similar to your regular assessment delinquency percentage. So let's say you have 8% of your owners not paying. You may want to add 8% to the special assessment amount. So make the special assessment higher by 8% than you normally would, because you're thinking, hey, maybe these people are not also going to pay the special assessment. Another thing that you may want to do is, give people payment plans. If you're worried that, hey, they can't make a $2,000 payment all at once, let's give them a payment plan so that they can, pay this over time, and therefore they'll be more likely to pay it. Obviously, if they don't pay it and they don't want to do any special payment plan that you have the same rights that you would have, legal rights, as they weren't paying their regular assessments. You can lien them, file a lawsuit against them, get a judgment against them, potentially foreclose if they meet the threshold for the foreclosure requirements. So lots of different options for your association. Question 27, what if there is never 1/10 of the owners who show up at meetings? We only get 1 to 5 people in 25 years. Well, a couple things. One good thing is that means things are going well. So you don't have a lot of people coming to your meetings, because trust me, the association where things are not going well have, standing room only at their meetings, lots of yelling and screaming. So things must be going well. Well, a couple things that you might want to consider. Our cheat sheet on annual meetings has some great tips on how to increase attendance. Make it a party, have a party in conjunction with it. Have it on Saturday morning, a time that maybe might be better for the residents. Plan it in conjunction with an event. There's a number of different suggestions that we have to increase attendance and to try to get a quorum of members at, meetings in the membership. If this is just regular meetings that you're talking about, continue to publicize when the regular meetings are and hope that the owners, that are interested will come. If they're not coming, though, it usually does mean that they are happy. Okay, question number 28. I was on the board last year and we updated the bylaws. They were not notarized or registered or recorded with the Maricopa County Recorder's Office. The one and only person on the board says that they are not valid and insists on going by old bylaws. Is our only avenue to vote him out and be on the board as an only board member, since the other owners refuse to be on the board? Okay, lots going on in this question. So when you update your bylaws, just so you know, you do not need to have them notarized, and you do not need to record them with the Recorder's Office. The only thing that you have to do is follow the procedures to amend the bylaws and have the board president and secretary sign the final version of the amended bylaws and put them in the association's records. So the current board member isn't correct on that. You may want to share this video. We share these videos on our websites. You could scroll to this section, number 28, and have this board member listen to it. And I can say the way the board did it was valid. Is your only avenue to vote him out? If that doesn't work, yes, you can remove him. We talked about the removal process today. You could also, hire a lawyer to write him a letter and let him know that, hey, the bylaws are valid. You could file a lawsuit against the association. I'm not encouraging you to do that. You could go to the ADRE, Arizona Department of Real Estate, to have an administrative law judge rule that the bylaws are valid. These are all different suggestions. Write this board member a letter, expressing your concerns. Run for the board yourself when the next board meeting's up. Next board election's up. I mean, it's kind of odd that you only have one person on the board, so maybe see if you can get appointed to be on the board. These are all good suggestions. Question number 29. Our association needs to discuss communication from our legal counsel within a short timeline in order to respond to a different attorney's communication to us. We want to have this discussion in executive session. Can we convene an executive session by itself with one topic without it being part of a regular board meeting? So short answer, yes. Or do we need to convene a board meeting or emergency board meeting with one topic and then immediately go to executive session? So good question. You can just notice it as an executive session and go into executive session. If it's an emergency and you can't wait 48 hours, then just do an emergency executive session meeting and then read into the record at the next regular executive session what happened, what the emergency was, and attach the minutes to that next executive session meeting. Question number 30, can an HOA limit the number of non-related individuals living in a single rental? That's a good question. We've had that many times over the years. It's really difficult to do that. You may want to check with your city, town, or municipality to see if they have any specific, restrictions on that you might be able to enforce. Typically, they're unwilling to enforce it, in my experience. I mean, it just depends. Is this like a party house where they've got 30 people living in a 2-bedroom? Then maybe the city will get involved, or maybe the association will get involved because they're creating a nuisance. But is this a family that has multi-generations living under the same roof? I wouldn't get involved in that because I think that could raise some fair housing implications. We don't want to get sued for a violation of the Fair Housing Act. So I think we got to look at that on a case-by-case basis. You're welcome to reach out to me and we can talk more about it. Question number 31, what recourse does a sitting board member have when the other directors make decisions without involving the full 3-member board? Some matters involving individual homeowners are being discussed informally, which seems to violate HOA law and fiduciary responsibilities. So, well, you only have a 3-member board, so 2 out of the 3 talking about things is a violation of the open meeting law. So I think you just need to raise the issue and say this needs to end. Okay, next question. Let's see. If several members at a board meeting call out the board members' failings, breaking of laws, not following governing documents, and ask for the board members to resign, can any board members that are left appoint anyone to fill the openings of the newly resigned board members? Or should another process be followed? This really is going to be in your bylaws. Typically, the sitting board can appoint new board members. There's always some discussion about should we throw it out to the community and say, hey, is anybody interested in being on the board? Give us your name and a bio, or can the board just hand select somebody without doing that? There really is no hard and fast rule on that. But typically the bylaws do allow you to do that. Question number 33, ARS states that the board, Arizona Revised Statute states that the board shall allow a member or a member's designated representative to speak once after the board has discussed a specific agenda item, but before the board takes formal action on that item in addition to other opportunities to speak. Does this mean that owners only have the right to speak on agenda items that are being voted on and not other agenda items that do not require a vote? This is a good question. So my opinion on this is that the board only opens it up for homeowners to comment before the board takes formal action on an item. Now, some boards also will do a homeowner forum, and that's great. I totally love that idea. I think it's a great idea. I do it at our association, and sometimes we have homeowners that come and want to talk. We listen. Great communication to have a successful association. But so, to answer your question, I think my interpretation of the law is that you can only, as a homeowner, contribute at a board meeting under the law when the board is going to take formal action on something. So it's an agenda item. The board's going to vote on it. There's a first, a second. Now we go into discussion. That's the time if you're a homeowner and you want to talk about something that you need to raise your hand and say, I would like to make a comment on this. They can put a time limit on it, but you do have a right to speak at that time. You don't have a right to speak on other agenda items if the board is not taking formal action on it, unless the board voluntarily allows you to do that. Okay, question number 34. This is a condensed version. In our condo association of 250 plus units, one family controls the HOA board and management. Family members are both directors and community manager, and together they own about 10% of the units. The board allows the manager, who's a family member, to act as the real estate agent for HOA unit sales, earning commissions even over another director's objections. My request to switch to a third-party management was rejected. Is it legal for one family to hold this level of control? It's unusual, I will say that. They only own 10% of the units, so my advice would be get control of the board. Get the other 90% of the owners to wake up and get some non-related people, handling all these responsibilities in your association. Okay, question number 35. A new neighbor with a common wall smokes on his back porch, 18-7. His action is filling my property and townhome with pungent, unhealthy cigarette smoke. And if I open up my porch doors to get fresh air, our antiquated HOA CC&Rs have an annoyance or nuisance article, not non-smoking. Our community manager recently sent him a letter as to neighbor complaints with no relief. As a long-term owner with valley fever, do I have any legal remedies? You probably are considered, if I had to guess, as having a disability under the Fair Housing Act. And so I would approach it from that angle with your association and just indicate that, hey, this is a problem and I'm asking for a reasonable accommodation. And this is a nuisance. It's making it difficult for me to breathe. And, we need you to take some sort of legal action to address this nuisance. And hopefully then the association will get more serious about contacting the owner. The owner should not be allowed to do that. If it's creating a nuisance for somebody else, you may want to get an air purification system. If I had to guess, if they're not on their back porch, then they're going to go inside and smoke. So you may want to consult with a separate air purification company too, to give you some advice on how you can limit that, negative impact of the cigarette smoke on you personally. Okay, question number 36. Looks like we've had a couple questions added. So we're down to our last 6 questions. Does the open meeting laws apply to architectural committee reviewing individual homeowner applications? Seems like it runs into an executive session function area. Definitely not an executive session because it's not, architectural committee is not going to be something that falls under those categories unless like your attorney's involved or there's, thinking about suing somebody over an architectural thing. It wouldn't go into the executive session territory. Technically speaking, if the architectural committee is meeting on a regular basis, then it would, be required to be, an open board meeting. We're going to have to notice it 48 hours in advance. But if it's not regularly scheduled, then you wouldn't have to. Best practices would be to make that an open meeting because it directly impacts other owners. But you're not required to unless it's regularly scheduled under Arizona law. Question number 37. I live in a new community and the management company is allowing rental of the clubhouse space to non-residents without any notification. These events take place 50 feet from my front door. What can I do? Okay, so you live in a new community. I'm assuming that means a newer, like it was just developed, and now the management company is allowing rental clubhouse space. I think you probably need to get an attorney to look at your documents to see whether or not this is something that's allowable and maybe have that attorney write a letter. If you want to contact my office, I'm happy to give you some referrals of owners or attorneys that represent owners to help you with the situation. Question number 38. A lien was placed in 2024 on a property for non-payment of assessments, fines, and fees. The amount owed at the time of the lien has increased since then, although the lien states that the charges due may increase. Is the lien updated with the current amount, or is this automatically done should the property be sold? So if there's a lien on the property from 2024, and that lien should be sufficient. You don't need to keep updating it, and it will be paid when the property is sold because that lien will need to be released, and there'll be a payoff request that's sent to the association. And the association will give them the updated figures, and the title company will collect the money at the time of the sale. One thing I want to mention is that you cannot in Arizona lien for fines, and so want to make sure that that's probably I don't know, put in there that the lien has fines in there. We cannot lien for fines. Just I want to make that very clear. If anybody's thinking about doing that, Arizona law does not allow us to do that. Okay, last 3 questions. Do you have guidelines or advice for board members using social media in their communities? I do. Be careful. Use social media to notify the residents of, the pumpkin patch you're having, or the board meeting, or the annual meeting, or road closures, or problems, but don't use social media to fight about issues. So board members should not be commenting on social media. Other than please come to our next board meeting so you can ask this question or hear our response to this issue. So that would be used as a communication tool, but not as a tool to, have disagreements with owners and engage in unprofessional dialogue. Okay, question number 40 from Facebook. Great to have you here. Our HOA board recently adopted new architectural standards without providing details or allowing owner input. The standards authorize a 3-member architectural committee, including 2 board members, to approve architectural requests outside of meetings and claim those meetings are closed to owners. A board member also stated that a board can make decisions outside of meetings with only 2 members' approval. Does this violate Arizona open meeting laws, and what actions can owners take? So hard for me to comment on this without seeing your association CC&Rs and knowing how many board members you have for your community. But it does seem, I have to look at your documents truly to answer this. Oftentimes, first, under Arizona law, one of the architectural committee members who's chair of the committee has to be a board member. That's under Arizona law. And having a 3-member architectural committee with several board members is, not unusual. Now, if it's a quorum, if the 2 board members is a quorum of the board, you may have to notice the meeting as a board meeting, even though it's an architectural meeting. I don't like the idea of board members making decisions outside of, meetings with only 2 members' approval. I'm not hearing emergency, and I don't know if 2 members is a quorum or not, but it seems like it's violating open meeting law. Okay, our last question for today. What are you hearing about turf reduction for HOAs? I've heard about third hand that any day now, HOAs will have 2 to 3 years to reduce down to 10 acres of turf or face state fines. If it does come out, converting lots to turf water-wise scaping will be very expensive and potentially even prohibitive. Go to our website because I know we have a number of blog articles on the water restrictions that have been in place by the state of Arizona. And so there definitely are restrictions that are in place. Just go to our website, mulcahylawfirm.com. It's mostly applying now to like the larger associations. So I'm not sure it's trickled down to the, smaller size associations. And again, this would be like the turf that the association's common area turf. So you'll have to see where you are in terms of your association, how much turf you have, and whether this is going to apply to you now or in 10 years or whatever. But I think everybody can agree that, converting from turf to desert landscaping is something that a lot of associations are considering, talking about for a number of reasons, because it saves money on landscaping costs, saves money on water costs. It's aesthetically, in some cases, more beautiful than having, some old Bermuda grass. I personally am from Wisconsin. I love grass, but I think you can have a happy medium in there. A couple things to think about. If you're an association that is thinking about converting from turf to desert landscaping, check with your city because they have a lot of grants available where it could be 50-50 or 40-60. And the grant money resets typically in July 1st every year. And so you might be able to get the city to partner with you to convert from turf to desert landscaping. It might be an efficient way to, save some money for your association. So I encourage you to take a look at the blog article that we've posted here. And if you have any questions, please feel free to contact our office. Okay, wow. We had 172 owners today at peak. That is amazing. So happy to hear that. Thank you so much for being here today. We only have one more virtual class in 2025. Wow, this year has gone by really fast. And that's going to be our December virtual HOA Condo Academy. We're going to be doing it on a different date because of the holidays. So we're going to be combining our first Friday, our firm's live virtual First Friday event on Friday, December 5th, with our December virtual HOA Condo Academy. So we're going to have a twofer. And we're going to be going live on Friday, December 5th at 9 a.m. on Zoom and Facebook Live. And I'm going to be answering any question that you may have. So deck the halls with questions, please. This session is going to be dedicated to providing answers to your HOA or condo legal questions. We're going to be sending out lots of reminders so that we can get as many questions as possible. And that will be our last virtual HOA Condo Academy. Remember, it's going to be on a different day this year. It's going to be in conjunction with our First Fridays, which we've been doing it this way for the past few years, just because the holidays, where the holidays fall. So we hope that you will join us for our last event of this year. Just in my concluding remarks for today, I hope you and your family and friends have a wonderful Thanksgiving. I'm very thankful for my entire Mulcahy Law Firm team and for all of our virtual viewers who come religiously to these classes and want to improve your communities. I hope that you have a safe and happy holiday, and I look forward to seeing you again on Friday, December 5th. Take care, everybody. Happy Thanksgiving.